record, so everybody will remember that from last meeting. And so I recorded it. The way it worked is that I had interest for about 2 or 3 days for people to see the meeting. So I'll leave it up and running publicly for a couple of days and then take it down and put it into the archives. So that worked out pretty well, I think. Okay, so let's call the meeting to order. Peter, you'll see everybody who's here. I have regrets from Gil, Rob, Howard, and Francois has left us. He sent me an email basically setting out that his work schedule just isn't going to permit him to continue working with us on the PRC. So I sent him my regrets and thanked him for his service. And we'll get to Francois's duties for the PRC and have hopefully somebody to replace him on one of the committee works. Okay, so next we have the approval of the agenda. So everybody should have the agenda. I sent it along this week with everything attached to it. So can I have someone to move to adopt the agenda?
I'll move.
Oh, Sean moved in a seconder.
I can second.
Brendan, all right, thank you. All in favor? Wonderful, thank you very much. Okay, can I have everybody looked at the minutes from our meeting on the 9th of November? So can I again have a mover to adopt those minutes? Oh, Andrea, someone to second that? Brendan again, or Kyle, either was fine. All right, Peter, so Peter's got that. So they're, and all in favor of the agenda or the minutes as printed? Good, thank you. Okay, so moving on to news and announcements. I was hoping to have Lynn Smith join us in this meeting. She was with us the last meeting. The last meeting she was there on an ad hoc capacity. She asked if she could become a member of the PRC. She's a past member of the PRC, so it was a pretty easy answer for her. She was welcome to join us. Oh, and wait a minute. I think she's coming. So hang on a sec. So Lynn, this is Lynn Smith.
Yes, thank you.
Yeah, hi, Lynn. I don't see your last name, but that's fine. Sure, you're on your iPad. We're just at the point in the agenda where I'm introducing you as a new member, but really a recurring member. So everybody has seen Lynn's CV. It's incredibly impressive. She's certainly worked diligently for the federal government for at least the last 20 years. Lynn, did you take a few moments to just introduce yourself to everybody again?
Hi, everyone. I was first became a member of the CCJA and the PRC back when I graduated from university several years ago. How did this happen that we got so old all of a sudden? My interest in criminal justice has been growing over the last decades, but specifically in cybersecurity and crimes of that nature. I find IT security incredibly important, and also issues of diversity and inclusion, women working in IT and in the security fields, be it policing, as the national intelligence officers, you name it. So that's really where my interests and background lie. Thank you.
Well, thank you, Lynn. So on behalf of the PRC and all its members, welcome back. It's lovely to have you. Okay, next issue is the item of mandate letters, both relative to Lametti as the Minister of Justice and Marco Mendocino as the Minister of Public Safety. Unless it's updated as of this morning, the mandate letters haven't been issued yet by the Prime Minister, which is a very odd kind of thing at this stage in a new Parliament. They usually come out much sooner than that. Has anybody heard of them being issued? I hadn't as of this morning. No? Okay, so that's we're just going to wait. I presume, and hopefully by, well, who knows, they're going to break for Christmas soon. See if they, whenever they're issued and whenever they are, I'll certainly post them and we'll discuss them. Okay, anybody have any other news or announcements that you'd like to put on this agenda that I haven't already included?
No.
Okay, we're good. Shaking some heads. That's fine. Thank you. Okay, business arising. So we're going to quickly go through updates on the parliamentary committees. There's not much to report, except we have one exceptional memo regarding that, which I'll get to. Howard and I are doing justice and human rights. So again, they just met to get themselves in place and who's going to be the chair and what have you. So nothing has really happened. I'll be able to report, I presume, next meeting with a little more substance on the creation of the committee. The next committee on public safety, commons, public safety and national security. Rob sent his regrets. I do have a memo or an email from Rob basically saying that again, they've met as well. Jim Carr has been appointed as the chair of the committee, and nothing else has happened other than that initial organization. So there's nothing to report there. On the Senate Legal and Constitutional Affairs Committee, we've got a exceptional memo from Sean and Brendan on the initial setting up of the committee. So if either one of you fellows want to say a few words about this committee, please do.
Happy to do that, and thanks for the compliments about the memo. It was fun to put together, and happy to take feedback anytime too, if anybody sees anything in there. I caught a couple spelling mistakes, but that's on me. But right, so the committee met twice since our last meeting. It was on December 7th and on the 10th. On the 7th, it was pretty much operational roles and duties of the committee, and on the 10th, the committee considered clauses 1 to 5 of Bill C3, which is an act to amend the Criminal Code and the Canada Labor Code. And so at the December 7th meeting, the only really relevant things that happened was Senator Mobina Jaffer was appointed as chair. Senator Pierre Hughes Boisvenu was appointed as the deputy chair, and Mark Palmer is the clerk. That's pretty much all we would need to know for that. And for the December 10th meeting, so clauses 1 to 5 of Bill C3, the bill, it creates new offenses.
Sean, excuse me, I'm sorry, I should have said this at the beginning. If I could just stop you there.
Yes.
I'm going to come back to you and Brendan in the bill section of our agenda for
Sure.
Bill C3. So let's discuss that in a little later in the meeting. Anything else with respect to the organization of the committee?
I'm not sure exactly what you mean.
Oh, the chair's been appointed. The committee has met. And if there's anything else other than Bill C3, you can report that. Otherwise, we'll deal with the bill in a few minutes.
Right, that's all there is. They only considered that so far.
I appreciate that. Thank you very much.
I might just add really quickly, sorry, they're supposed to meet again tomorrow, so it seems like it's a pretty busy discussion going on.
Good.
Thanks,
Good.
Brendan.
Thank you. Yeah, an exceptional report on the beginnings of this committee. So thank you very much, guys. The next committee is the Human Rights Committee. Now, Francois, up until yesterday, was handling that, but again, he's now recused himself from the PRC. So is there anybody that I can get to take over watching this particular committee? So again, this is the Senate Committee on Human Rights. Not at this point. Okay, so I'll send it a call to the membership as a whole to hopefully find somebody to report for this committee. Thank you. Okay, next, the status on the work of the subcommittee on racism. This is now a totally separate committee for the CCGA, as far as I understand. Irving and Peter, do you have anything to say about that?
If I can, Miles,
Sure.
You can hear me okay?
Yep, please do.
The board decided to change the title of that committee, and now it's going to be the Committee on Social Justice. We sent out, or I did send out a call for nominations or submissions to be the chair of that committee. I haven't received any nominations yet, so we're still waiting for that. And then the next step would be obviously for the chair to gather together a committee and start working with it. One of the important elements of it is the need for that committee to work closely with the PRC, obviously, in the future. Peter, you have anything else to add on that?
No.
You okay with that?
Okay.
Yeah,
thanks,
that's
Irving.
okay.
Oh,
My finger kept on slipping on my button. No, I've got nothing more to add. Thanks, Irving.
Okay,
Great. Thanks, Ernie. Thanks, Peter. All right. So for the most part, this item can come off the agenda, and just by way of following up on Irving's comment. So what will happen, of course, and I think this is the way it should happen, is that any briefs that the PRC prepares for consideration by the CCGA will be run by this committee as well for their input. I think that's an appropriate way to deal with these things. Kyle, leave your hand up.
Yeah, just a quick question. I was curious, I know, safe for finding a chair. Are there any proposed or ambitious timelines with respect to when the social justice committee may, start its work?
well, it's going to be hard to do without a chair, right? I guess, we're what, 10, 12 days from Christmas. So I guess after the new year, if we don't hear any nominations, we'll have to go back to the board, maybe deputize somebody as an interim chair. That would be one way of doing it. And then that person could start gathering together members of the previous subcommittee and possibly, or probably others as well, and start formulating an agenda for it.
Okay. Thanks for that, Irving. Thanks, Miles.
You're welcome.
Thanks, Kyle. Thanks, Irving. All right, guys, moving on. The next item is the Criminal Cases Review Commission report. I sent this along to you. I mentioned this in the last meeting. So what has happened this year is that there was the formation of a committee to look into essentially creating an independent from government commission to look into the issue of essentially wrongful convictions for the purposes of reviewing convictions to exonerate offenders who may well be incarcerated, and or exonerate those who are released but still have this tarnish their name, of course. So the committee did a lot of work over the course of last year. It prepared a report about a month ago, submitted it to the Department of Justice. It had to be translated into French, which is a standard operating function of what happens with these things. And so last week, Mr. Justice Harry Laforme and his partner in crime, Justice Juanita Westmoreland Traore, prepared the report and made it public because it was approved for purposes of publication. I've circulated to you two things: an executive summary of what the committee came up with, and the recommendations. And it's very exciting. It's very exciting to me because it's my area of expertise. So I consulted on the report. And what it basically does is it calls for the establishment of what they want to refer to as a miscarriage of justice commission. It will be a totally independent body from the government. The way things work right now, if you believe you are wrongly convicted, you make an application under 696(1) of the Criminal Code. It would go to a criminal conviction review group working within the Federal Department of Justice, and then that process works its way through to a recommendation to the Minister of Justice, who then makes a decision whether the case will actually have a new trial, or more often than not, referred back to the Provincial Court of Appeal where the conviction took place for a new appeal. So that's, so it's offering a new process. The commission itself would have that authority that the Minister of Justice currently has. So it in fact can recommend going back to a Provincial Court of Appeal. The grounds for consideration are much broader. It doesn't require the proof of factual innocence, which is the mainstay of the current process. So it goes beyond that, which is a very liberated view of things. So at this stage of the game, it's in Lametti's hands, the Minister of Justice. It was in his original mandate, or his mandate letter of 2019, to create this commission. So there's no reason to expect that it won't go forward. It may not go forward on the premise of all the recommendations that have been made, and there's plenty of them, and they're very, very well thought out. The committee, talked to other commissions that exist in the UK. There was a conviction integrity group in New Jersey. There is a very new commission in New Zealand. New Zealand is a brand new one, so this particular committee took a lot from the recommendations from New Zealand because it is very well thought out. Anyway, the long and short of it is that it's in the hands of the minister. It's exciting for those of us who work in the field of wrongful convictions. So we're just waiting to see what the minister comes back with and the process. The process actually calls for, again, the establishment of a commission with 9 commissioners. And those 9 commissioners, 3 of them will be from experts in the field. 3 of them will be from practicing lawyers, and 3 of them will be from groups that tend to be targeted for wrongful convictions, which are marginalized groups, Black and Indigenous persons. So that's a very nice mix, we think, and and they will be appointed in the same way that it's an independent appointments process by an advisory committee, and they will be appointed in the same way that Superior Court justices are appointed at the same level of pay, for instance, which is a pretty significant salary. So it looks to be a very professional organization, one that should stand apart from what the government does on its own. Any questions about it that I can tell you? Okay, so let's leave it at that. I'll keep everybody up to date on how it progresses through the hands of the minister and take it from there. Okay, next we have the CSC. So since our last meeting, the CSC has released a report on its stakeholder roundtable, which took place in June of last year. And the report sets out what we heard. So I've given that to you. It's available. Hopefully you've had a chance to look at it. Irving, you're probably the most connected with this proceeding. Anything you have to say about it?
No, nothing much. Actually, it was Howard who attended on our behalf. And if you look at the report, you'll see basically CSC saying, thank you very much. It was a wonderful exercise. It was useful, etc. And we'll try to, or we'll use the ideas that came forth in future operations of the SIU. I think what's significant, of course, is that Tony Dube is no longer head of the advisory committee, or review committee, and it's Howard Sapers was appointed some little while ago. So that I don't want to overstate it, but it should keep their feet to the fire to a more significant degree, I think.
Yeah, it's a shame to lose Tony Dube. I mean, he's excellent in his field and very straightforward and forthcoming in how he feels about these things. So it's a loss. There's no question about it. Howard had a couple of months ago, and certainly before he left, had some comments about his participation or what he took from the participation at that roundtable. So when he comes back to us in the new year, we'll probably get Howard to say a few more words about it.
That'd be good.
Anyway, at least it's a good thing to get this for the CSC to get it out into the hands of everybody to take a look at. So please do. And following up on that, and we did this last meeting as well. Andrea gave us a few words about SIU and what was happening in Yukon. And I don't think, Andrea, you had anything to add to that, unless I'm wrong.
Miles?
Oh, yes, Matthew.
May I ask whether this could be a continuing agenda item?
Absolutely. There's no problem. Yeah,
purposes to police this. Of course, I'm more on the academic side, so the loss of Professor Emeritus Dube concerns me because I know why he left. So I think it would benefit all of us to have this as a continuing item for follow up, because I'm intrigued as to what the Corrections Penitentiary Service is going to do.
Did you want to share with us why Tony Dube left?
Well, he left because he was frustrated at essentially being ignored by Corrections Canada and being stonewalled on the data. In fact, they even renounced the integrity of the data they gave him.
Okay. All right. Thank you for that. Yeah, absolutely, Matthew. We'll keep this as an ongoing item on the agenda. So we'll come back to it again next month. The next issue is that of John Howard and the NAACJ initiative. I have nothing to add on this. I haven't received anything further. So Again, I will keep it on the agenda because there is an ongoing obligation to the federal government to implement the framework dealing with this issue. So it's pretty much a waiting brief, and I'll keep it active. Hopefully something comes to us that we can discuss. Next, on the engagement of StatCan's police reported Indigenous and racialized stats, Irving and Kyle are keeping an eye on that for us. Anything to add today?
Can I go back a step, Miles?
Sure.
Pardon me. The framework to reduce recidivism, by the way, I've taken part in a number of sessions. There were, I think, every 2 weeks with NAACJ people. But at the same time, I think it was mentioned last time, public safety also set up a number of Zoom meetings. I took part in those. There was 2 of them. So we had most of the NAACJ affiliated organizations taking part in that. And they've devised, I'm not sure where it's going to go next. I think they're supposed to do a report based on our Zoom meetings, our virtual meetings. And they set out a number of pillars that I've been looking at in terms of the impact of those elements, if you like, such as education, employment, and so forth. Mental health was another one of those, what they call pillars, in support of reduction of recidivism. So you had these 2, frankly, the day or the day after we had the last session with public safety and company, hardly anybody attended the NAACJ one because we thought one was subsuming the other. But in any case, the NAACJ one seems to be continuing under the particular guidance and of John Howard. We'll see where that all goes.
All right, thanks very much, Irving. So again, we'll keep this on the agenda and come back to it next month to see if there's anything to add. But we appreciate you filling us in. So that's terrific. Thank you.
Can I jump into the next one?
Yep, yep, next again, yep.
Sorry, I'll let Kyle get in anytime he wants. Kyle, we received a fairly lengthy questionnaire some time ago, and with a relatively short timeline. I think we had to submit it. I can't remember. Kyle perhaps remembers better. It was about 3 weeks ago, and we did. Kyle did most of the work in responding to the questions. I added a couple of things, and I should say that before I turn it over to Kyle, we also had a virtual meeting with Stats Canada. This is all about disaggregating data to reflect the need for more information on Indigenous and racialized statistics and so forth. I was a bit surprised. There were 3 of us, only 3 of us on this virtual meeting, led by or moderated by Stats Canada. So I'm not quite sure where that's going to go, but we were basically, if I could say it this way, we're trying to teach her how the thing works, so to speak, because this was a statistician who was not really familiar with the area. So I'm not sure where it's going to go, but basically it was a repeat. She was basically reintroducing the same questions that we'd already responded to in written format, which is kind of, that's all I have to say. Kyle, would you like to add whatever?
Yeah, so sadly, I didn't have the opportunity to participate in the engagement, but it sounds like I did not miss a lot. I think, Irving, you did a good job summarizing essentially what they were asking for, where from my perspective, I think it's the opportunity to kind of either articulate or put on paper some ambitious goals with respect to both collecting and publicly disseminating racially or disaggregated data more generally. And those have to be the 2 core components from my perspective. So we're obviously not advocating for, or I would not advocate just for collection outside of like this public dissemination exercise. The other reflection I would offer is that it is very similar to the other kind of StatsCan led consultation earlier on over the summer. Mm-hmm. I think as an organization, we should kind of strategically poke and inquire in terms of what's happening with the progress on things. I certainly don't want to see either our input falling flat or something not being done with it. So I'm most curious about like getting some status updates at some point in time. And from my perspective, the biggest deficiency in both consultation documents was kind of the lack of an attempt to identify or articulate a gold standard. So it might be looking towards another jurisdiction for ideas. It might be about trying to communicate what, for example, Statistics Canada wants to achieve. But from my respectful position, both keeping tabs on this and trying to hold Stats Canada's feet to the fire and working towards the ideal end state or some type of a gold standard would be really kind of meaningful and strategic for the CCJA. I'll pause there. And so just for some context, because I think there's some new folks on the line as well. We had, I believe, almost a year ago, it would have actually been a year ago, reached out to StatsCan following the kind of joint letter announcement between Statistics Canada and the Canadian Association of Chiefs of Police, where there was an interest in doing and reporting on disaggregated data, where the organization offered their kind of input and advice and all of those good things. It kind of fell flat or kind of fell off the radar, I think, through no one's fault. So just trying to incorporate some bigger picture lessons learned, those 2 points I mentioned, I think would be really important for the CCJA. I'll pause there. Thanks.
Yeah, thanks, Kyle. Do you see us having a role right now, the PRC having a role right now in communicating with StatsCan?
Well, given that it's only been a couple of weeks since that most recent CCJA interjection, there might not be an immediate role, but for those who are interested, if anyone else is curious in this topic, I'll also turn my mind to it first thing in the new year. I suppose a friendly follow-up would be prudent and probably safe, and maybe more importantly, low effort.
Okay, well, let's keep it on the agenda then, and we'll come back to it in January, and when everybody's refreshed, hopefully.
Fair.
Okay, thanks, guys. Okay, all right, so new business. So we have a draft brief. This is a slightly revised brief that we had last month, but we didn't discuss it because we were holding off until this meeting, prepared by Brendan on rural crime. And so we have his updated brief as an attachment, together with a repetition of the proposed Alberta Provincial Police position paper attached as well. So Brendan, do you want to give us your overview of the brief, please?
Sure. I just prepared a little presentation for the brief just to go through it quickly, but I just want to thank everyone for taking the time to read it, and also for those who sent me some advice. I appreciate it, and I took it into consideration. So the brief I prepared, it's for Bill C-289, which is an act to amend the criminal code in sentencing. It was introduced in the previous parliament, so obviously since the election, it's fallen to the floor. However, for a variety of reasons, firstly, elements of this bill are still officially in the Conservative Party of Canada platform, as can be seen in the document that Miles sent out. So despite the fact that this bill has now, the original bill at least has fallen, I believe that a similar bill will arise in the future. And I think it also touches on important aspects of Canadian Confederation, namely crime and victimization in rural areas. Of course, this is a very important issue in the prairies. And for that reason, I think it's important to look at this bill regardless. So this bill was proposed by a Conservative MP from Alberta who has since been reelected. It was Blaine Calkins. It sought to do three things. The main thing I'll touch on instead of going into all of it, just for the sake of brevity. This bill sought to create an aggravating factor of sentencing, whereby those who offenders who targeted an individual based on their remoteness are punished more severely. So in short, I think that this proposed piece of legislation, though it's praiseworthy for its desire to help victims or look into victimization in rural areas, I think that the proposed legislation is deficient and potentially discriminatory. Firstly, the term remote, as is used in the bill and trying to define remote victims, there's no agreed upon definition of remote. And as such, it can be quite subjective. And I think that would mean that the definition of remote would fall to the courts to define that through jurisprudence at a time when case backlogs are already increasing. So that's not ideal, in my opinion. Secondly, in general, the addition of aggravating factors, I think, can hinder individualized sentencing in a given case. And of course, my understanding of the CCJA is that it's a big proponent of individualized sentencing. And in general, I think aggravating factors can hinder that. I can go into more specifics later, but again, for the sake of brevity, I'll just continue. The third issue that I see in this bill is that it's dubious whether or not factors that increase sentencing severity will actually deter individuals from committing crime. And I'll get into some corollary concerns shortly. So in addition to those three main issues, in addition to those three main concerns, equity concerns emerge with this bill. And this arises because a large number, Indigenous peoples are overrepresented in rural areas. So while 18.5% roughly percent of non-Indigenous Canadians live in rural areas, 38.5% of Indigenous peoples live in those areas as well. So in short, Indigenous peoples are overrepresented in rural areas. So given these concerns, I have three main recommendations, and they all revolve principally around further research and consultation with rural stakeholders. So the first recommendation was the striking of a federal, provincial, territorial working group on crime and victimization in rural and remote areas. This would help develop knowledge and sharing that knowledge across Canada. Secondly, it recommends public safety and the Department of Justice retain researchers to analyze existing data on crime and victimization, while also undertaking consultations with stakeholders, as I mentioned earlier. Third, it recommends the evaluation of rural policing programs that have already been instituted in Alberta and Saskatchewan. And with that, it recommends that those evaluations be shared with the country in order to increase our understanding and knowledge of these policies or these programs. So in summary, I believe that there are issues. In summary, this brief shows, I think, that the CCJA takes the issue of crime in remote areas seriously, and it is concerning. However, the proposed legislation is unlikely to have a positive impact in these communities. Rather, the impacts would be negative, particularly for groups that are already marginalized. So thank you for your attention, and I look forward to any comments, concerns, or feedback.
That's an excellent brief.
Mr. Chairman, may I intercede?
Certainly.
When we don't have an active bill against which to file a brief, do we file it or do we hold it as a matter of procedure?
I would hold this until it's reintroduced. It's a private member's bill. It's been done twice before. I anticipate it would be done again. So in reality, I think what we do is we wait until it comes back up as a private member's bill. We ask Brendan kindly to update his data in that regard, and then bring it back for adoption.
The second issue, Brendan, I would enjoy some comment from you. It's my understanding that the policing in a lot of rural areas is actually federal under contract, RCMP contract policing, which kind of is interesting that it pertains to our own federal law enforcement agency. Did you wish to make a recommendation along those lines?
So thank you for pointing that out. You're 100% correct in that regard, that it's RCMP members under contract. I think actually in the Alberta, in that report about Alberta policing and the potential establishment of the Alberta Provincial Police, they speak a great deal about the RCMP in those roles. At this moment, I don't know if I have a reservation. It's something that I think would likely be something that should be added. So I don't want to stick my foot in my mouth and say something wrong, but in short, I do think that that's something that should be added and considered. So thank you.
Thanks, Matthew. Peter, you're the one that brought the APP position paper to our attention. Do you have anything to add?
Just that it's still very much a fairly hot issue here in Alberta, especially with the police union pushing back against the government of Alberta, which in itself is very precedent setting. I don't think it's been done since Ramel in Toronto went after the politicians there years and years ago. So that's a very interesting piece. Matthew, totally correct again, as Brendan said. It is the RCMP under the provincial policing contract, which is really where this is centered on, although they also hold contracts with municipalities as well, which brings up the whole issue of who is responsible for what. And if you look at Robert Lunny, Bob Lunny, used to be a Edmonton police chief, then a Winnipeg police chief. He has an excellent article written about this and the whole issue of accountability, or actually the lack of accountability, which is really the key focus here. I can send that article, the name of it, I'll attach it to the minutes, just so you can take a look at it. It's well worth the read. And in fact, I believe it's quoted in that document regarding Alberta policing. In fact, it is quoted in there. I wrote it. So I just remembered. Yeah, it's actually quite a complex issue. It's more than just rural crime and victimization of rural people. It's the actual the whole issue of asymmetric policing in Canada, which underlies all of this. So without me getting on my high horse, that's enough. Thanks.
Thanks, Peter. Any other comments or questions for anybody?
Just a question for Peter. In terms of responsibility, when there is contract policing in a province and/or municipality, do they report to the Attorney General of the province, or do they report directly to the Commissioner of the RCMP?
Technically, they actually, that's the problem, Irving, is that when you're dressed in different clothes and trying to wear them all at one time, on one side, they are accountable under the RCMP Act, which takes precedence, but the Alberta Police Act also has a precedent there. In terms of oversight, they have police committees, which are totally ineffectual, in my opinion, compared to a police commission that other municipalities are obliged to have under the Act. So really, at the end of the day, it's maintain the right and follow the Royal Red.
Thanks.
Okay.
I have a bias.
Yeah. No. Thanks very much, guys. Let's keep moving. All right. So, and again, so for the purposes of clarity, so we'll revisit this when another bill, likely a private member's bill, is introduced, and we'll get Brendan back on that. So, thank you very much again, Brendan, for an excellent brief. All right, guys. Next item is Irving received an invitation letter from the Privacy Commissioner of Canada regarding facial recognition guidance, and there's meetings that are scheduled to come up regarding that. The letter is basically asking whether we want to send somebody, and Irving brought this up, send somebody to participate in this. Everybody's got. I gave you the facial recognition invitation as an attachment. So this is this is an issue obviously between the utility of facial recognition by police services for the purposes obviously of crime prevention, investigation, or what have you, versus the very real rights of individuals to privacy. And there's obviously a real opportunity for those two issues to collide in the real world. So at this stage of the game, I think it's just fair to say, do we have somebody who is prepared to participate in the meetings that the commissioner wants to establish?
Just to jump in, I would be really interested in this. It's an area that I'm relatively familiar with and have a lot of personal interest in the whole issue, both in terms of support for the technology, but also recognizing, on the other hand, the misuse of the technology. And also how reliable is the technology, and also how ubiquitous it is in places such as England and in China, which is really quite something. And so I have an interest in this area, so I don't mind after this week is over, I'd be glad to put something together and run it by you, Miles, or bring it back to the PRC before anything goes on. I haven't seen a timeline for the meeting, but I doubt it'll be before Christmas.
No, that's great though, Peter. Thank you very much for volunteering. Irving, can you forward the email you received from the Privacy Commissioner? Can you forward it directly to Peter?
Sure.
Thank you very much.
Welcome.
Okay, guys, next item, and then I'm keeping my eye on the clock here, so I apologize if I sound like I'm rushing you. The next issue is a request for us to join what's called the Fresh Start Coalition, which has actually been established by the Canadian Civil Liberties Association. This is a coalition of 40 odd justice groups across Canada who, and there's been a lot of publicity about it. I gave you an article in the Toronto Star of November 17th and some CCLA material. So this is a coalition that's basically said that what we need, and this follows up on the work that Kim Pate has been doing in the Senate and the work that we've done previously with respect to the replacement of the existing record suspension system in place. Used to be the pardon system. Harper changed it in 2010 and 2012 to record suspensions, and this is a promotion by the virtually any justice group that has any sway in the country. So we were being asked to join it to basically convince the government, the federal government, that a spent conviction regime is the way to go, which simply means that instead of somebody who has a criminal conviction basically having to apply to the Parole Board of Canada for the conviction to be now suspended, perhaps pardoned, but basically, expunged under this regime, that it will take place automatically after a period of time has gone by. So if you've been convicted and you've lived crime-free for whatever period of time seems appropriate, and the working formula seems to be crime-free for 3 years if you have a summary conviction, and 5 years if you have an indictable conviction. So that seems to be the working ratio. So we've been asked to join it. I think that we should, but it's open for discussion because it has to go to a vote at the CCGA for that purposes. We actually, I have an email from the CCLA encouraging us. They'd be very pleased to have us join the coalition. So that's something I followed up on in anticipation of this meeting. Does anybody have any questions about this? Again, it can be about the briefs that we previously prepared. I prepared 3 or 4 briefs based on the various iterations of the legislation that was being put forward by both Senator Pate and by the Commons. So any questions on this? Yes, Matthew.
I thought we were generally in favor of a new regime with respect to prior records. So just as a matter of procedure, Miles, does this go, if the PRC makes a recommendation, does that go to our board for approval, or do we have standing to join for the association?
It's a good question. Irving can probably answer that better than I can. I think it should go to the board, failing which I'd certainly want to do it on behalf of the PRC, but I like to see the CCGA itself behind this. Irving, what do you think?
I think it should go to the board. You recall, frankly, I don't even recall all the details because, as you indicated, there's about 3 or 4 briefs as time went on and so on. I do seem to recall that we were not 100% behind Kim Pate's suggestions or proposed legislation. So what was approved last time by the board would be slight modification from Kim Pate's version. So joining the coalition, does that put us squarely behind Kim Pate's proposed legislation, or does that provide us with some opportunity to say yes, but we would like to see this or that modified kind of scenario?
Yeah, the coalition isn't based upon Senator Pate's draft bill. It's her input, in the legislative scheme of things, is on this side of the aisle. The coalition is a totally different entity. Does not rely upon. It certainly endorses some of what Senator Pate was putting forward. but it's not by any means adopting her position and then putting that forward itself. So it has its own mandate, and so and hopefully you can see that from the CCLA material I sent. So that's what the board should be considering. What the mandate of this coalition itself, and if it supports that, then of course agreeing to join the coalition, which I would certainly support. But again, I think it should be a board decision.
If we support the coalition, does that still give us some autonomy in the subject matter?
I'd have to go back to the CCLA about that. I doubt it. I mean, I think the strength of the coalition is the fact that it's got a unified position endorsed by all of the justice groups that are part of it.
I'll have another read of the documentation too.
Yeah. So perhaps you and I, Irving, we will coordinate with the content and the procedure and take it from there. But what I need from the members of the PRC is those who are in favor of putting this before the board. So if you give me a show of hands, then I appreciate that.
Well, I make a motion that we put it before the board and seek the board's direction.
Yes, thanks. So that's the motion. And can I have a seconder?
I'll second it.
Thanks, Stefan. All right, and all in favor? Great, thank you. It's great. Okay, so leave it with Irving and I will get on that and sooner rather than later and report back to everybody at our next meeting. Good. All right, let's see where we are now. The next item is this is before we get to the bill, so we're not doing too badly for time. There is I received an email from Howard yesterday. It was, and I sent it to everybody as an adjunct to our original agenda. It's an analysis done by the Pro Bono Student Canada group, which Howard is very much connected with, and he has 2 students working with him on various things. And one of the things he asked them to do was to prepare an analysis of the 3 major political parties, what their platforms effectively were regarding criminal justice issues, and also what are the issues in the speech from the throne on criminal justice issues. And they prepared a report. It's a lengthy report. Obviously, it's very well done, and so I appreciate that. But I'm proposing that we discuss it at our next meeting. We don't have the time to do it in this meeting, and it did just come to us yesterday, so I want to give everybody a chance to read it and digest it. So does anybody have any questions about the report as it stands, or do you want to discuss it now, or are you prepared to wait until next meeting?
Just a comment that it looks good.
Okay.
I concur, Miles, that we should adjourn the matter to allow us to look at it. These are political platform matters, and we all know that the history of them is replete with nothing happening.
Right. Appreciate it.
Remember there was a song, Promises, Promises? Who was that? Dionne Warwick? So, I said to Howard, I think this is really interesting information, kind of background information, but don't hold them to it.
Exactly. All right, guys, so let's put it over for further discussion in detail next month. Okay, so it's about 10 to 1. We're not going to get out of here by 1, but I'm going to, because we already have some people dropping off. So I'll do our best to be out of here in 15 minutes if I can. So turn to the issue of the bills. So obviously at our last meeting, Parliament hadn't convened. There weren't any bills put before Parliament, either the Commons or the Senate, but now there are. So I've prepared them for you. What I've done, a little bit different than the way Howard used to do it, is what I've done is I've been encapsulated with each bill the purpose and the explanatory notes for the bill, so everybody has a pretty good idea of what they're dealing with. So the first one we'll deal with the Commons, and then we'll deal with the Senate, and we deal with the Commons public, then private, Senate, public, and private. That's the process. So Bill C3, an act to amend the Criminal Code and the Canada Labor Code to create an offense of intimidating a person in order to impede them from obtaining health services. Clearly, that relates to COVID to a great degree. This is now the subject of the bill and the committee work that Sean and Brendan did. So if you guys want to give us a brief overview of what the committee has done in this regard, then we'll take it from there.
Sure. So, got a little bit of feedback there. So because the synopsis that you put there kind of addresses the offenses that are created under the bill, I will just skip over that for sake of time, if that's okay, unless you'd prefer that I do.
No, no, please go.
Super. So from the Senate perspective, we were looking at the commentary that happened at committee, and something that Brendan mentioned that I just recently caught is that the draft report will be considered by the committee tomorrow, but that will also be in camera, which is how they ended the meeting, which I will lead to in just a moment. But notable commentary that did take place. Minister Lametti, he spoke in motivation of the bill and had two witnesses from the department to support him, but they did not make comments. Answered several questions. And while speaking in motivation, he did say that the contents of the bill would apply also to more contentious health service providers like abortion clinics, which I thought was an interesting way to get to that point. So that was a comment that stood out for me. Outside of that, the bill intends to encourage police officers to make arrests by increasing the maximum penalties regarding intimidation, obstructing access, or mischievous property damage from 5 to 10 years, and that's over the course of all of those offenses. In the minister's view, the increased maximum sentence is intended to demonstrate that the federal government's not going to tolerate this kind of behavior from protesters. And the new provisions, they build on existing offenses of intimidation and mischief of property. So the committee, they asked several questions to clarify what the intentions of the bill were. And I found that the questions focused on the federal government's consultation with provinces, as well as his level of confidence that the new provisions would be enforced at the local level. So a couple of comments that came from the different senators. Conservative senators mentioned that it would be more effective to impose mandatory minimum sentences, which I thought was interesting in terms of convincing officers to arrest demonstrators. But the rest of the members of the committee didn't really get behind that, which was encouraging to see. And the other members of the committee recommended imposing fines instead of imprisonment, which could also encourage officers to make those arrests. The progressive senators on committee asked about whether the contents of the bill would apply to public institutions like schools and whether adequate consultation was undertaken with provincial ministers of justice. I think the reason that they asked about schools is because of how the case law has evolved for the sections of the charter that are implicated for the protesters around these institutions. Right. So the ministry didn't rule out those conclusions, but he did confirm that the provisions were targeted to healthcare facilities and their workers. So a bit of a dodge there. And in terms of consultation with the provinces, the minister confirmed that each of his provincial counterparts, they understood the scope of the proposed law and their duties in terms of its enforcement. But outside of that, he did leave it to their decisions to enforce because it falls under their purview. Right. And lastly, Senator Kim Pate, as we know and love, asked the minister to how the minister intended to prevent sophisticated protesters from abusing the defense that's incorporated into the bill. Sorry, I guess I must have had a little too much coffee while we were in the meeting.
No, I appreciate the speed.
All right, super. Preventing the sophisticated protesters from abusing the defense because they could claim that they're simply sharing information at the health facility as opposed to obstructing. And the minister explained that the new provision requires demonstration of a criminal mens rea. And with that, it would be hard to dodge those requirements in that sense, at least from what he was explaining. And he also referenced that provincial offenses also cover this area related to exemption zones around health facilities, which is a strict liability offense. So the mens rea wouldn't even really be considered in that sense. After all of that, the committee deliberated on the contents of the bill in camera, and then the meeting adjourned. And then, like I said, they're going to be going over the draft report tomorrow, and that's in camera too.
Thanks, Sean. So just moving forward, oh, I'm sorry, Matthew.
Question. Do we have a draft bill commentary on this issue? And the second issue is, I recall one or more of the senators raised the issue of whether this particular bill was even necessary. And the reason they did is because there are already provisions in the criminal code that deal with harassment and interference, and that since it's the local departments that initiate the arrests, this is not an issue of a problem with the code. It's a problem of enforcement, largely against white people. I'm sure if they were natives or black people, we'd have a different response. So I'm just wondering if that was a matter that we should address.
Well, Matthew, I mean, your first question, do we have a commentary? Yes, it's what Sean just gave us, because as a function of timing, all these things have taken place in the last month. Second thing is that in the normal course of events, bills that are of interest to us, we would prepare a brief. I try to get somebody to do that. In real terms, however, for this particular bill, it's going to pass very quickly. It's going to go out of committee almost immediately. In real terms, there's not going to be any impact we'll have in preparing a brief, reviewing it next month, and then forwarding on to CCGA, the board, because it's going to be history before we get that far. So unless somebody has a burning desire to prepare a brief that we can forward after the fact, my suggestion on this one is basically to accept Sean and Brendan's report as submitted, and then leave it to next month to see if in fact it's enacted, in place. That's my suggestion. I'm certainly open to responses to that.
I agree. I had follow up with Matthew's question. There was commentary talking about the duplication that is arising from this. And I think that the Conservative senators were kind of moving towards that, but they ran out of time in committee. And they commented that they will bring that up in revisions for the draft report instead.
All right. Thanks, Sean. Thanks, Matthew. Okay, so I propose that we put this over to the next meeting without any further action taken. Okay, good. Bill C4, this is obviously something that's been in the news the last week or 2 weeks, the incredibly expeditious passage of the bill on to basically criminalize conversion therapy or further criminalize conversion therapy. It had 3 readings of the Commons, the Senate, and Royal Assent within a matter of weeks. So it's been unanimous. So everything's in place. Again, it's not something that we can do anything about if we, in fact, ever wanted to. It's just something we basically at this point acknowledge as being put into place. Certainly we can discuss it as a group for the purposes of our own edification. Nothing from a policy review point of view we can do, however, at this point. Anybody have any comments about the law affecting conversion therapy? I think pretty much everybody pretty much accepts it as obviously a good thing, I don't think we need any further action at this point. It's now enacted. Okay, Bill 5, an act to amend the criminal code and control drugs and substances. So what this does, and again, I apologize for my haste. What this does essentially is it tries to remove some mandatory minimum penalties and enhance conditional sentences to reverse essentially what Harper had done in his tough on crime agenda, which was to in fact put in place a good number of mandatory minimums. One of the ones he did put in place, this is about 2013, 2014, I wrote an article on it actually, was put mandatory minimums in place regarding anybody in possession of a gun during the commission of a crime. Whether the gun had anything to do with the crime or not was immaterial. And likewise with drug possession. And so mandatory minimums were put in place, obviously, in that regard, and certainly dealing with drug offenses, it does target marginalized communities, Black and Indigenous Canadians, more than anybody else. So the purpose of this bill is to remove the imposition of mandatory minimums and to enhance the availability of conditional sentences. So for those of you who don't know what they are, that's house arrest to a great degree. That's what conditional sentences are. Which allows those who are convicted to have the opportunity to serve their sentence in the community, which means they get to keep going to work and still have relations with their families. They have very strict curfews and what have you as a function of that, but it keeps people from actually being imprisoned. So that's where we are. It's had first reading, nothing else at this stage. This is probably something that wouldn't hurt to have a brief on going forward. I think it has issues that are relevant to what we see as being justice perpetuation. So any volunteers to prepare a brief on this? Okay, not at this point. All right, I will put it out to the larger membership and ask for volunteers. Okay, the only private members bill in the Commons that we're dealing with is Bill C-202, which is a very simple one paragraph bill that basically addresses intimate partner violence, and it allows for earlier intervention, which creates an offense for anybody who believes they're being intimidated, essentially, in an intimate partner relationship. So the whole purpose of it is to basically stop, or giving tools to victims primarily of partner violence, to give them a tool to stop the perpetuation of that kind of violence. So it's had a first reading and nothing further. Anybody have any comments or questions about this particular bill? Okay, Kyle, your hands up. No, I don't have it. There's no microphone for Kyle, but I see a hand up. Yes, no? Okay. All right. Okay, I presume that Kyle doesn't want his hand up. So,
Sorry, did I hear my name?
oh yeah, you did, Kyle. Yeah, I see your hand.
Oh, it's a ancient hand, or I can't explain why it's up.
No problem. Okay.
Legacy hand.
Yeah, that's right. Okay, so again, any volunteers for a brief on this matter? Okay, I'll put it out to the membership then. Thank you. Okay, let's turn to the Senate. Bill S3, an act to amend the Judges Act. So what it proposes is to establish a new process for holding judges' feet to the fire, more so than what's currently in place, which is a complaint to the Canadian Judicial Council. If a judge has gone, somebody thinks the judge has gone sideways in what they've done, and there's a couple of pretty wide or pretty well-known examples the last 10 years. Justice Douglas in Manitoba, she was a justice of the Court of Queen's Bench, Manitoba, who didn't tell anybody when she was applying that there was a video of her, it was a sex tape, essentially, that her husband, her late husband, actually filmed and published, to her chagrin. And she had accelerated through the Court of Queen's Bench, Manitoba very, very quickly. She went from a provincial court judge to being the vice the assistant chief justice of the bench in a relatively short period of time, as in 4 or 5 years. And it took probably 6 or 7 years going through the Judicial Council before she just resigned. It was a mess. It was a terrible, terrible ordeal. And so she's no longer on the bench and what have you. And then we have Justice Robin. Gosh, maybe somebody can help me with this. He was the judge that basically in a sexual offense trial told the victim that she should have kept her knees together, basically. And so he likewise was heading down the road to being removed from the bench before he resigned. Resignation, obviously, of course, preserves pensions, rather very nice pensions, actually. So Senator Pierre Delphont is the senator who put this forward. Whether we think this deserves a CJA brief or not, I don't know. If we don't have anybody volunteering for it, again, I'll put it out to the membership. Yes, Sean.
I am actually interested. I got to write an opinion piece on this bill, and it is a very positive step forward in terms of the process.
Excellent. All right. Well, that's super. So you're the man, Sean.
Right on.
So please prepare your brief, and we'll get it to me, and we'll take it from there. So that's great. I appreciate that. Thank you.
Happy to.
And lastly, we have private member bills in the Senate, which by their nature don't go very far, very fast, but here's what they are. So the first one we have is Bill S-206, which is disclosure of information by jurors. This is trauma for jurors, which actually is very meritorious. What it does is that it takes out of the criminal code the penalties for basically jurors releasing any information whatsoever regarding their participation on a jury. What this allows them to do is to engage their experience with a mental health professional to deal with essentially PTSD. I guess that's a very broad way to expand it or explain it, dealing with their participation on a jury. I've given you a CBC News article attached to this particular bill for you to take a look at. It's had 3 readings in the Senate. It's now on its way to first reading in the Commons. So there is time for us to act on that if we want to. I mean, I see a lot of merit in it. I don't see anything that would be a negative impact of this bill. So we can, yes, Irving?
Miles, I did not have a moment to double check, but this is the brief that Francois did some while back.
Okay, clearly I don't have that, but if he did, I can ask Howard to forward it to us.
I can't recall if it went all the way, but this is the one where I'm trying to remember all the details, but we wanted to include a representative of faith communities if the individual wants to confer with that person, the individual ex-juror, and so on.
Okay,
Does that ring a bell?
it doesn't for me, but it may for others.
It does for me, yeah.
Yeah, it does for me as well.
Oh, good.
Let's dig it up and see where it's at, quite frankly, because obviously it was before the elections and so on. I'll look in my electronic files. You could do the same, Miles, and see. I'm pretty sure it went to the board, but I'll have to double check.
Okay, well, if you do that and get back to me, I'll put it on the agenda
Absolutely.
for next month. I'd appreciate that.
Certainly.
Okay, Bill, that's 212 to amend criminal records. This is basically a reiteration again of what is now we're looking at for the Fresh Start Coalition, which is a reintroduction of Kim Pate's bill with respect to moving from a record suspension to a pardon system. So at this point, I would, without doing another brief, which I would be doing, I would presume, without doing that, let's see where the board stands on the Fresh Start Coalition, because this may basically take us off this track and concentrate our efforts there. So unless anybody has any, Matthew, the question?
I concur with the chair's approach.
Yep, thank you. All right, so let's, any other comments or concerns about that? Let's do that. So that's our action for there. Bill S-213, this was an act regarding the independence of the judiciary, which again was a very, very small act, which simply meant that what was being proposed was that some mandatory minimums could be alleviated against if the judges published reasons for that deviation from the mandatory minimum, which in theory is a very substantial purpose behind the bill. I mean, that's giving judges discretion where previous mandatory minimums are put in place. It has been done in other jurisdictions, the UK, Australia. They do it that way. Olivia prepared a brief for us on this previously. I'll see if I can get my hands on it and bring it back. At least that's the note I had from Howard. Does anybody have any recollection of that? Irving shaking his head, which
Was this Kim Pate's bill?
I don't know, to tell you the truth. It's not. You think it's her bill now? You mean as opposed to previously?
I believe that previously it was her bill.
Okay.
I mean, remember, one of the things she's pointed out with respect to the administration's new bill on mandatories is that in Kim's view, it doesn't go far enough and it doesn't eliminate a whole lot of other mandatories. But I distinctly remember that she put a proposal together to give courts, that is magistrates, discretion to set aside the mandatory. Maybe I'm wrong.
Well, you're certain. I don't know if it's Kim Pate's, so I can check that. You're certainly right. I mean, the bill that we've already talked about in the Commons dealing with mandatory minimums, which is dealing specifically with impact on marginalized communities, is very limited in the mandatory minimums that are directed to be, basically opened up. Other than those, all the other mandatory minimums, mostly put in place by Harper, are still in place. So the concept behind this bill, to open up mandatory minimums to judicial discretion is a big deal if it applies to all mandatory minimums on its own. So leave this with me. I will do some more background checking on it to see if we have a previous bill and or what Kim Pate may have said earlier, and I'll get back to everybody on this to try to fill it in before we do anything further. And again, I don't know whether we have a brief from Olivia. Again, that's just a note that Howard gave me, but I can check
I
with him as
thought she
well.
was working on it, Miles. I don't recall seeing it. I
Okay,
can check with Olivia if you wish.
yeah, for sure.
Okay.
All right, so leave that with me, everybody, and I'll bring you all up to date next month. Okay, Bill CS 224. It's a bill to address trafficking in persons. Again, it's a very, very slight change to section 27904 of the criminal code. It's semantics more than substance. So I don't propose we do anything about this. I'll certainly watch it to see if anything happens as it goes through these various readings and the committee work. But I propose to leave this and I'll report back next month if anything's happening. Okay, S230, basically, again, it's directed towards the overuse of segregation, particularly for marginalized offenders. And its main purpose is to put into place judicial oversight of segregation. I mean, that's always been available by way of habeas corpus applications. But this is called TONA's or Tanya's Law. It's had second reading is currently in process. I've given everybody in the enactment the commentary on what it does. So do we have anybody who would like to prepare a brief for us on this? Again, it's still just past first reading, so we have some time. Anybody? All right. So I'll put that out. There we go, last one. Woohoo. Okay, Bill S231, an act to basically increase the use of DNA and its augmentation in DNA databanks. So this is certainly something that's been put forward and endorsed by the Chiefs of Police Association for quite a while. For those of you who don't know how DNA works in Canada, which is totally different for the most part than other jurisdictions. So for instance, in the UK, you get arrested, your DNA is taken, right? In Canada, DNA is only taken if you're convicted and there's 4 different levels of basically offenses that lead to the gathering of DNA. So, at the first level of offense, if it falls within the categories that are enumerated, DNA is automatically taken. And the next level of offense, DNA is presumptively taken, but the accused can argue, or the offender can argue against it. In the third level, it's not presumptive, but the Crown can ask for it. And in the fourth level, you have to beg and plead for it to be taken for whatever reason. So it's a graduated scale, and that's what we do. So for instance, at the top, if you're convicted of a sexual offense, your DNA is going to be collected, right? And then it goes all the way down to the fourth level. If it's some kind of an offense that has absolutely no relationship to the identification of an offender for future purposes, it won't be taken. So this has had first reading, and it's certainly going to be of interest. Maybe it's interest to Peter. It's a police related matter. What it simply proposes to do is to make us to create the expansion of the DNA data bank for the purposes of identification of criminals, both for investigation purposes and obviously for conviction purposes. So any thoughts or comments on this?
I'm interested in the area, but I got a little bit of a lot on my plate
You got a
right
lot
now.
going on, Sean, so we want to distill your work. Anybody else? Okay.
Can I throw in a little bit of info?
Sure can.
Those of you in Ontario in particular, if you have access to Toronto Life magazine, the latest issue in December, there's a really long and interesting article about the police officer who solved I think it's Christine Jessup,
yeah,
young girl it was Christine, was it?
Yeah, Christine Jessup, yes.
She disappeared in 1984 without a trace. They arrested and actually convicted on the second trial Guy Paul Morin, who spent a couple of years, I guess, in federal prison until he was let out. And it took somewhere in the neighborhood of what, 30 years to actually find the real culprit through DNA matching. It's a complicated process. Google Toronto Life magazine. If you don't have a hard copy, you might be able to see the article. It is really quite fascinating.
Yeah, well, and yeah, thanks, Aaron. You're absolutely right. I mean, it's the, and this has been done a fair bit in the United States, and this was a really famous case for us, where if familial DNA was used to eventually work its way through
That's right.
to identify the only possible suspects that it could have been, and so yeah, and honest, and I only say this because my former firm used to act for the Jessup family. I can tell you that they never, up until this particular point, believed that Guy Paul Morin was not guilty. You know, even when the scientific evidence at the scene did not point to him in any way whatsoever, they just couldn't let go of the fact that it was Morin. And until in fact they did this and identify the actual perpetrator without question, did they finally admit to it and actually apologize to Morin, saying, how sorry we are that we just could not believe it wasn't you. So incredibly interesting. And thanks for that, Irving, because it conceptualizes this. So does anybody want to follow up with this? And, okay, again, I'll put it out to the membership and hopefully whittle down the work on bills and committees for our next meeting. So that's it, everybody. So I apologize for going over time, and I apologize for sounding rushed. I wasn't trying to be. I want to make sure we covered everything. I think everybody got the chance to say whatever they wanted to say. Any comments before we finish off, other than wishing everybody a very happy holiday?
Stay safe, guys.
We're good. All right. The very best, everybody. You and yours have wonderful holidays. We'll see you back here in the new year. Thank you kindly. Take care, everybody.
Thank you, everybody.
Bye-bye. Take care.
Bye.